These are New Zealand's Crown-owned pine forests. They represent a multi-billion-dollar economic engine, with vast tracts of timber sitting directly on the government's balance sheet. Beyond the commercial value, these valleys are a flashpoint for Tino Rangatiratanga, the Maori right to sovereignty and control over their ancestral territories. For decades, the Waitangi Tribunal has investigated historical thefts of this land. In most cases, the tribunal only provides non-binding recommendations to the government. But the law contains one specific exception. Under Section 8HB of the Treaty of Waitangi Act, the tribunal can trigger resumption. This is a binding power that legally forces the Crown to return forest land to Maori ownership, regardless of the government's preference. This ability to unilaterally transfer state assets creates an inevitable collision between Indigenous claimants reclaiming their wealth and a state trying to protect its treasury. That collision has now escalated to the highest level of the judiciary in the 2026 case of Estate of Ruru v. Attorney General. Claimants representing Te Aitonga Amahi and Mangatuan Corporation are seeking to trigger this resumption power to recover their forests. Because the Crown is contesting the claim, the Supreme Court of New Zealand has stepped in to set the final legal boundaries for these land returns. The ruling will dictate exactly how difficult it remains for Indigenous groups to force the government's hand in returning stolen assets. The Supreme Court is acting as a gatekeeper, granting the claimants permission to argue two specific, highly technical points of law. The first point is the Nexus test. To reclaim forest land, iwi must prove a direct connective link, a nexus, between a specific parcel of trees and a proven historical breach of the treaty. The Crown argues for a narrow interpretation. If the court requires an incredibly strict link, the government can effectively insulate its assets from being seized. If the court interprets the nexus broadly, it empowers iwi to reclaim lucrative forestry assets across the entire country. The second point is the payout. The court is reviewing the formula the tribunal uses to calculate the extra financial compensation awarded alongside the returned land. The decision on these two grounds will establish the physical and financial architecture of all future treaty settlements. While 2 points moved forward, the Supreme Court shut the door on the claimant's third request. The claimants wanted a higher interest rate on their compensation. They argued that because Crown administrative delays dragged the settlement process out for decades, the final payout should reflect that lost time. The court refused to revisit its recent Wairarapa Moana precedent. By blocking the higher interest rate, the justices effectively locked the financial baseline at a lower percentage. This rejection insulates the government from compounding financial liabilities caused by its own delays, leaving Maori claimants to absorb the cost of time. This absolute power to override Crown ownership has fractured New Zealand's political landscape. On the right, National, ACT, and New Zealand First oppose binding tribunal powers. They prefer negotiated settlements to protect the Crown's balance sheet and prevent what they describe as judicial activism. In the middle, Labour attempts to support the tribunal's independence while keeping the process contained within historical settlement frameworks. On the left, the Green Party and Te Pāti Māori demand the unconditional enforcement of resumption powers to honour the obligations of Te Tiriti o Waitangi. The technical argument over a nexus has become a proxy war for New Zealand's broader identity crisis over historical justice. The weight of this dispute now rests within the Supreme Court courtroom. The verdict here will affect every contested hectare of Crown forest in the country. The Estate of Ruru ruling will redefine the limits of justice in Aotearoa, deciding if the power to right historical wrongs belongs to the politicians or the judges.